is appearing, that's the crime intelligence head, back in the Pretoria Magistrates Court for his corruption and fraud case, and this is after the recusal of the magistrate in Vusi Mahlangu. Let's listen in.
As well, Your Worship, that in the gallery, and I'm going to request Mr. Tefo to come closer, there's also Advocate Tefo, who just approached me, Your Worship, that he also wants to make an application to be a friend of the court, Your Worship. I don't know at what stage the court will accommodate that, whether we should start with Mr. Tefo's application as an amiras curiae before we get into the other applications. May Mr. Tefo introduce himself into the record.
Yes, my name is Dineo Mokwele. What brought me here, Your Worship, is that I want to bring the application for amicus curiae to be the friend of court. Let me say simple term, not the same much of relaxing, to be the friend of court in this matter. The reason is that I'm informed that the accused they are here to apply for the realization of their bail conditions. So, as a result of that, firstly, I'm also the accused. Another matter whereby your brother is appearing, acting chief Mahlangu. My matter is on the 22nd of October, next week Tuesday. So the reason for me being here and bringing this application is on the basis of the fact that the applicants are very dangerous people. I was in jail. They are part of sending me in jail. And when I was in jail, they were monitoring my communication in jail. Whereby Mr. Khumalo, the Divisional Commission, accused number 1 in this matter. He appointed President Moyano.
Objection, Your Worship. Your Worship, with due respect to my learned friend, there is no application, substantive application that has been brought before this court on papers for the request for my learned friend to be accepted as a friend of this court and to be able to stand before this court and be able to address this honorable court regarding the issues implicating my clients before this court. And therefore, my Lord, I ask that my learned friend be not allowed to address his lordship on the grounds and basis upon which he wants to apply as a friend of this court. And above that, the application will be opposed. In criminal law, we never have had such an advocate who wants to join the proceeding as a friend of the court. In civil court, yes, we do know the proceeding. It does happen like that. And my clients will be prejudiced should this court allow my learned friend, Mr. Tefo, to continue placing on record the allegations that he wants to place on record. And it is prejudicial, it should not be allowed. He cannot be allowed even to get a platform to address his lordship regarding such application. That is not proper before this court. Those are my submissions.
May it please the Honourable Court. Your Worship, I'm also of the respectful submission that learned friend Mr. Tefo should file his application with the clerk of the court and serve copies of his application to us as the state and to the defense so that we can have insight into what the application is all about, and we can then respond and set out whether what our view is regarding his application. I'm afraid that already he was going into the merits of what his issues are about without us having had sight into his papers. It's not that we've already made a decision on whether we're going to oppose or not. But if the court can make an order, we already have a date on which the case has been postponed to. Mr. Tefo can be given time frames on when to file his papers, and then the other parties can then respond. Okay.
Mr. President, do you have a response to the objection?
Yes.
Do you have a response to the objection?
I do have a response, Your Worship. Yes. Your Worship, I'm appearing here not as the counsel, as the applicant who is a normal citizen in this country, law-abiding citizen, who has been harassed and been persecuted. So hence I'm saying, I'm not objecting to that. I was saying that if I cannot seize this opportunity today, Your Worship, I'll be overtaken by the events. Because if this court can proceed to extend that the application of the applicants here be granted, that the bail condition be relaxed, because chief among the bail conditions that
I want to the objection which issues around the proceeding of the
just the last thing, is that yes, I was fearing that I may be overtaken by the events if I come later. So I'm amenable to bring the application in writing. So if this is not going to happen today, there will be a postponement. Then I'll be fine, and the court can make a ruling in terms of release the one to file and all those things.
At this stage, I will not make a ruling as to whether or not a person can join criminal proceedings at the end of the court. But if we want to put an application, I will make a sufficient condition for the minister that you must bring a substantive legal application and must send Mr. Zulu and Mr. Zulu the application cannot be had.
Yeah. And it's very important also to highlight this point. I'm also objecting the inclusion of the council in Sholola itself.
No.
That is, I will address you.
I've made a ruling, that is the end of it. Mr. Zulu.
As the court, please. Your Worship, back to the main matter which is before this court. In brief, the accused 1, 3, and 4 in the main case are applicants in this matter in terms of Section 63 to amend a bail condition which was set by your brother, Mr. Mahlangu. The proceedings started on 22nd of August 2015 and postponed to 2 other dates, and yesterday on the 14th of October Mr. Mahlangu then recused himself from the proceedings on the basis of the events that are happening at both the Mahlangu Commission and the parliamentary portfolio proceedings. He then informed us yesterday in court of his reasons for recusing himself, and that's how then the matter was then reallocated to you as a new presiding officer in the case. We have since, as the state's team, looked into the decision of Mr. Mahlangu to recuse himself, and we are of the respectful submission that it ought not to have happened the way it did, and that it's not in compliance with Section 22 of the Superior Courts Act, and therefore, on those bases, we intend to make an application to the High Court to have the decision of Mr. Mahlangu recusing himself from these proceedings reviewed and set aside. We have already compiled our papers, Your Worship. This morning, the investigating officer just deposed an affidavit. We are on our way to the High Court to set those. We have a copy that we can show to the court as proof of what we're going to file later today. And as a result, we are not in a position to start with a new Section 63 application today, since we are reviewing the decision of Mr. Mahlangu. It is not going to serve the interest of justice, Your Worship, that whilst we are reviewing the decision of the presiding officer, that we start with the process again, because there's going to be two parallel processes running. I just want to. I have a copy for Ms. Mishololo, Your Worship. These are documents that we're going to send this morning in High Court. It's a notice of motion compiled by us, the state, and in support of that notice of motion, we've attached the affidavit of the investigating officer, Mr. Brian Badayashi, who's with me today here in court. It's also attached to the application.
Your Worship. Firstly, Your Worship, the magistrate yesterday recused himself from these proceedings. And we indicated, we've asked that if that is the case, that the magistrate has recused himself, let another magistrate be appointed and the court be allocated, so that the application in terms of Section 63, subsection 1 of the Criminal Procedure Act that we are bringing before this Honorable Court for the amendment of bail conditions, be able to proceed before another judicial officer. Now, Your Worship, the state makes the submissions that they intend to review such an application, such a ruling by the magistrate, which is a recusal. And there are no bases placed before this Honorable Court showing the prospects of success in that review, as the state reviewing the magistrate when the magistrate himself has recused himself. The requirements for the review, the basis and the grounds for the review have not been placed before this Honorable Court. I have not been served, we have not been served. I'm sitting in front, next to me, my instructing attorney, Mr. Shawan. We have not received, we have not been served with any papers for the application for any intended review. My submission, Your Worship, is that these proceedings, the application in terms of Section 63, cannot be prohibited or cannot be prevented, cannot be disallowed to proceed because of the wishes of the other party. If the state intends to bring such a review application, they have a right to do so, they have a right to file their application, we will be served. And also, Your Worship, the fact that the other party intends to review or intends to appeal does not mean that the application cannot proceed before this Honorable Court. Whether it was the appeal or whether it would be the review, there is no application for the stay of proceedings in terms of Section 63 of the Criminal Procedure Act, pending the finalization of the review that the state intends to bring. Therefore, it is my submission, Your Worship, that the clients are suffering prejudice from day one in August, when they firstly approached this Honorable Court for their application to have the bail condition that is preventing them to go back to work and be able to execute the duties in terms of the SABC that are empowered on them. There has been an unreasonable delay up until today. Therefore, it is my submission, Your Worship, that the applicants are suffering prejudice because they are unable to go to work. And if I may put it to the attention of this court, that the issue of bail condition is a matter of agency. Because after the the bail condition was granted, it appeared that they are unable to execute the duties. That is the main reason they came before this honorable court. If the court is going to allow the time that is unknown to this court, there are no papers that have been filed with no date when that matter will be set for hearing in High Court. So it means the applicants will be prevented from going back to their work. When the suspension of when the letters of their suspension from work has been lifted up by the National Commissioner. The National Commissioner, the state is aware that the National Commissioner has lifted up the suspension and had said under oath, Your Worship, that they must go back to work. That is the reason we are here. We had to approach this honorable court to have that bail condition amended. In the event, my lord, I submit that the court is inclined to grant the state, which has never happened in our law, to grant someone to proceed with the review because we have no papers that have been filed in court. I would ask that the bail condition that you are asking that it be amended pending the finalization of the review that the state intends to file. Secondly, my lord, this is a bail application. The ruling for the magistrate is not even appealable. And it does not necessarily mean that the bail on recusal. That does not necessarily mean that the proceedings for the bail application, for the amendment of bail application should be stopped. There is nothing, there is no rule preventing, there's no provision preventing this honorable court from hearing the application for the amendment of bail conditions as it is set to proceed today. Until that decision, because even that decision, even if it can be granted in the High Court, we are making submissions on speculations which were not allowed to address his lordship on speculation of the review of which you don't even have the text of such a review. It's my humble submission, Your Worship, that this matter should proceed before this honorable court today to allow the applicants to go back to work pending the finalization of the review by the state as the court reasons.
Thank you very much. The brief background of the issue I see at the moment is exposed. You are advocating for the relaxation of the bail condition for heard by my brother, Mr. Mahlangu. I'm informed he recused himself from the case in the light of what transpired at the Mahlangu Commission and the Parliamentary Committee. Today, the prosecution has given me an indication they intend to file for review of the Mahlangu's decision to recuse himself from the case. The application is being opposed by Mr. Mkhwanazi on the basis that the prosecution has not shown that there are broad success of the review application. I have to say that the intention by the bill to file a review is an inter process. In any case, criminal case, if there is an interrogatory process, it has to be disposed of before we can get into the main issue. And the intention by the state to file a review does not require permission from me. They can do the court permissions. Unlike in a criminal case where an accused has been convicted and sentenced, and one of the parties want to appeal, they have to bring an application for me for leave to appeal my decision. With a review, as it is an interrogatory process, they don't require my permission. All they are required to do is to give me notice that they intend to do that, and I cannot stop them. So we have to allow them that opportunity and see what the outcome of the review is. Mr. Mkhwanazi has submitted that if I grant the state that permission, then I must relax the bail conditions. The relaxation of the bail conditions is the bone of contention in this case. I cannot make a ruling before I've heard the prosecution and the defense on the issue. In the circumstances, I will allow the prosecution to file their review. The main issue cannot be dealt with today until we have the outcome of the review.
Maybe the matter then be remanded already. There was a date. What is the date? 6th November was the date to which the main case has been postponed to. May this be accused also then the matter be postponed to the same date. In the interim, we'll be filing our documents before the end of business today. Proof of service of our notice that the High Court will then be provided to the legal representatives. The 6th of November. The accused are on bail of 10,000 rand each. May it be extended.
Is the date in order, Ms. Mkhwanazi?
And that the matter be remanded back to court 16th.
Is the date in order, Ms. Mkhwanazi?
Yes, the matter is adjourned until the 6th of November.
Matter then remanded 6 November 2025, court 16 for outcome of the review application, be in court 8:30. Call it again.
All right, so these are the visuals we've been beaming to you from the Pretoria Magistrates Court, the corruption case involving crime intelligence boss and 6 others being postponed to the 6th of November. It seems the bone of contention is around this recusal of the magistrate, which the state, it seems, wants to appeal. I stand to be corrected. We'll certainly get some of those details ironed out. Not the best audio quality coming from the court. But also, in an unexpected turn of events, we're able to see Malisela Tefu there, who's asking to be admitted as a friend of the court. He's alleged that the applicants, these are the accused, are dangerous people, he says, who he also adds have led to his being arrested. You might remember Malisela Tefu reached notoriety in some respects in the sense of Meyiwa murder trial, and in fact, given the debacle there, he was struck off the roll from the legal practitioners. In fact, it was the role of legal practitioners, that's the right term. They also ordered that he return his certificate of enrollment as a legal practitioner to the registrar of the court. What is important to emphasize is that he says he's not there as counsel, but as a layperson, as a civilian, I think is the more accurate term, and wants to be submitted as a friend of the court in order to bring forward his own evidence against the accused in that particular case. It's, like I said, an unexpected turn of events, but we'll see how all of that pans out, with the judge really just moving his case to the side, asking for a formal application before any of what he says can be entertained by the court itself. So the 6th of November is the date. We'll certainly keep watching that story very closely for you to get your sense of what he has to say. And we'll take you back to that court if any of the accused, by the way, give an impromptu briefing to journalists.